We'll have argument this morning in our first case, Golden Corral Corporation versus Illinois Union Insurance Company. And we'll hear from Appellant's Counsel whenever you're ready.
May it please the court. My name is Will Hartzell, and I'm here on behalf of Golden Corral. Your Honors, two insurance coverage cases with the same facts, the same policy language, and the same law should reach the same result. This matter and North State Deli.
Do you think that happens frequently with insurance? You know, that these policies are pretty similar across, multiple insureds, and there seem to frequently be events that affect numerous insureds, right? Hurricane, a flood, damaging hail, things like that. Surely this comes up frequently?
Your Honor, surprisingly it does not. And I think that goes to the uniqueness of the COVID-19 pandemic and the response.
But won't it come up frequently if we agree with you that that similar factual circumstances and similar policy language mean that the cases should be kind of open to reconsideration whenever there's new law?
Well, Your Honor, I think the key point in this case is a tight nexus between North State Deli and Golden Corral. And that nexus is rooted in the various government orders that shut down operations in North Carolina.
Because it's not rooted in the same contract, is it?
No, it's not. But it's rooted in similar contract language.
Similar. It's not even verbatim the same contract language.
No, but it uses contract language that's promulgated by industry organizations that the insurance companies adopt in whole or in part. It both uses this language.
So just to be clear, this claim you're making is not limited to your client. It's literally any company that previously litigated and lost this issue could now move to reopen the final judgment.
They could move, Your Honor, but I don't know if those motions would be successful. Rule 60.
I mean, the mere fact that they could and that it would be prima facie plausible motion suggests, as I think Judge Rushing suggests, this is a potentially very sweeping holding you're asking for.
Potentially, Your Honor, but we're asking for a holding that would affect all cases with materially identical policy language, all cases affected by the very specific government orders, specifically the March 17, 2020
Okay,
order.
but every single state in the country issued COVID shutdown orders.
But the nexus in this case is the March 17 order issued by Governor Cooper. It's what shut down the restaurants in North State Deli, and it's what shut down the North Carolina stores in Golden Corral. And Golden Corral is a North Carolina company. Its heartbeat is in North Carolina.
Can I ask you about your certification argument? Because it frankly strikes me as bizarre. Why should the fact that the North Carolina courts have chosen to be a massive outlier, because the last time I checked is literally the only state in the country that doesn't allow certification in some circumstances. So why should the fact that the North Carolina courts, for reasons that are good to them, have decided to not even allow a federal court to ask them pre-final judgment what the answer to a state law question is, why should that make it easier to reopen a final judgment?
Your Honor, because it places individuals like, or companies like Golden
Take
Corral.
it up with the state of North Carolina.
Your Honor, but we did not remove this matter to federal court. Illinois Union removed this matter to federal court. We filed this case in state court. And when Illinois Union removed this case to federal court, they are the ones that deprived the North Carolina courts.
And so once you saw litigation was working its way through the state courts, you obviously moved to stay your federal litigation so that we could get an authoritative construction from the North Carolina courts, right?
We did not, Your Honor.
In fact, you actively opposed that.
Your Honor, we actively opposed a stay of discovery pending the court's consideration of a motion for judgment on the pleadings. We did not oppose a stay of the litigation.
Did you ever ask for a stay of the litigation?
We did not, Your Honor. But by the time this case had ended and this court had affirmed the trial court's grant of motion for judgment on the pleadings, the petition for discretionary review in North State Deli hadn't been granted. There was no certainty that this court.
So you filed a cert petition with the Supreme Court to try to keep your case non-final as long as possible, right?
Your Honor, we did not file a cert petition.
So you made a variety of tactical choices that seemed like the good decision at the time and simply didn't work out the way you hoped. I don't know how that's extraordinary circumstances.
Your Honor, I would point this court to Justice Jackson's dissent in the BLOM bank matter, where she talks about the litigation choices that bear fault when seeking Rule 60b-6 relief. And she talks about the litigation choices that end litigation. We did not make any choice to end litigation.
Well, you did. You didn't seek in bank and you didn't seek cert. That was a choice to let the litigation end.
Incorrect, Your Honor. We did seek in bank.
I'm sorry. Thank you for correcting. You didn't seek cert. That was a foregone choice to keep the litigation pending.
No, we did not. We did not seek cert. But no court has ever held that the failure to seek cert bars you from seeking Rule 60b-6.
No, I'm not saying it bars it, but why is it relevant to, I mean, your claim essentially, and look, there's a lot of intuitive force to this. This seems weird, it seems potentially wrong, it seems potentially unfair, I get all that.
Yeah.
But that's not the test. The test is whether there's extraordinary circumstances.
And I would point this court's attention to the Pierce case and its progeny that established that extraordinary circumstances exist when two related cases proceed. One is state court, one.
Is Pierce the one where it was the exact same vehicular accident?
It was, Your Honor.
Okay, so that's not just related, right? It's the same
There's a
event.
very tight, yes, Your Honor, there's a very tight nexus. But I'll also point this court's attention to the Second Circuit's approach in the terrorist attacks case, in which there was a wide-ranging group of plaintiffs, individuals injured in the 9/11 attacks, property owners, property insurers, who sought to hold the Kingdom of Saudi Arabia liable for those acts.
Sure, but why isn't that case different? Because the Second Circuit basically said, like, mea culpa, the whole reason that there's these cases that have different outcomes is because we, the Second Circuit, changed our mind about something. And that, like, it's our fault. Like, we did this.
Your Honor, you're right. The Erie component is not present in the terrorist attacks case, but the Erie component adds on top of what the Second Circuit did. The Sixth Circuit, in the Blue Diamond Coal case, recognized that the Erie component is one of the core aspects of the Pierce ruling, that when you have two litigations proceeding in state and federal court, forum selection should not be outcome determinative.
I mean, I know that's a good principle in theory, but anybody with even a passing familiarity with Erie doctrine knows that there are routinely outcome determinative differences between being in state and federal court.
There are, Your Honor, but they're not when we have two cases that are so closely related. We have two cases arising out of the same government order, this March 17 shutdown order.
Well, that's the framing that you want. I guess to go back to what Judge Rushing started with, why isn't another way to say it is we have two cases arising out of different contracts between different parties?
Your Honor, there has been no requirement to have identity of contract.
Do you know any case that's applied this transaction test in the context of a contract claim? They all seem to be tort claims to me.
Your Honor, they are, and I'm aware of any case that has granted a Rule 60b-6 in a contract case. But Pierce does not talk about the type of claim.
I just don't think you're going to get that far with Pierce, because if we want to start adding additional differences between this case and Pierce, in Pierce, the 10th Circuit wasn't reviewing a district court decision for abuse of discretion. The 10th Circuit was making the decision itself.
That's right, Your Honor, and this is up here on abuse of discretion. But it is an error of law, or pardon me, an error of law is an abuse of discretion. And here the district court rejected Pierce.
What's the error of law?
In rejecting Pierce without any reasonable basis to do so. Because rejecting
It's not an error of law for a district court to disagree with a 10th Circuit decision. You have to explain why. Like, it's not district courts don't have to explain why they disagree with an out-of-circuit decision, do they?
Well, they have to offer substantial basis for the decisions they make.
How about this court has repeatedly suggested that it would be rare, if ever, that a change in law would get you extraordinary circumstances, which is what the district court said.
That's right, and this court has articulated that generally a change in decisional law does not entitle one to Rule 60b-6 relief. And I think, Your Honor, I think that holding mirrors the Agostini holding out of the United States Supreme Court, where that court held that intervening developments of law by themselves are not sufficient for Rule 60b-6 relief.
So what else do we have here other than an intervening change?
We
We have
have
a
the-
deferential standard of review, abuse of discretion. We have a very difficult hurdle, frankly, for your client with the extraordinary circumstances test. What else do we have?
Well, Your Honor, in addition to the change in law that came in North State Deli, in which the North Carolina Supreme Court clarified that COVID losses are covered by insurance policies with the language direct physical loss, we have this close connection between North State Deli and the Golden Corral case. Right? These matters were filed 4 days apart. Right? They're the same type of injury, under the same policy language, under the same body of law, and complain about the same government orders that shut them down. This is a very...
Even going back to Pierce, the language is the same transaction or occurrence. So even if we agree with you that these two cases are closely tied because they're connected to the same government policy, that doesn't make them the same transaction or occurrence.
I would disagree, Your Honor, but I would also point you to the Elite IT case out of the 10th Circuit, which was an updated Pierce filed in 2024, in which they described that Pierce is appropriate merely when there are factually related cases. Other courts in citing Pierce have talked about merely related cases. And, Your Honors, I would also point you back to the terrorist attacks case in the Second Circuit. The two cases there involved one lawsuit against the Kingdom of Saudi Arabia and another lawsuit against the state of Afghanistan, both alleging wide-ranging conduct in support of terrorism. So in that case, when they granted Rule 60b-6 relief and cited Pierce, those are two cases in which we did not have an identity of defendants, like we don't have here. But again, these cases are deeply related.
Weren't they all eventually going to be put in the same MDL? It seemed like that was part of the Second Circuit's reasoning, was that there was an MDL here, and one case was just late to the party on that, not because of any fault of their own.
I think that is true, Your Honor, but the Second Circuit also recognized how intricate the pleadings were in the terrorist attacks case, how complicated the facts were, but held that the logic of Pierce nevertheless should still apply. And I think that is wisdom that the Second Circuit is departing, that Pierce should apply regardless of the scope of the event. Yes, we have unified contract language here that the insurance companies have chose to use. And yes, we have a wide-reaching pandemic event that had a multitude of effects, which the logic of Pierce should still apply. The fact remains that these two cases are deeply related, and the only reason that Golden Corral lost coverage and North State Deli did not, or had coverage in the state court, was the fact that Illinois Union removed this case to federal court and deprived the state courts of any way to exercise any view on this specific policy right here. Your Honors, also want to focus on some of the case law that the district court used in rejecting Pierce, because it simply does not support the contention that Pierce should be rejected within the circuit. Most notably, it cited the McGessick case out of the Seventh Circuit. And the McGessick case specifically stated that the Fourth Circuit's approach to Rule 60b-6 jurisprudence and changes in decisional law is compatible with the Tenth Circuit's approach in Pierce.
Sorry, who said this?
The Seventh Circuit in McGessick.
With all due respect, why do I care what the Seventh Circuit thinks about the compatibility of our precedent with the Tenth Circuit's precedent?
Because, Your Honor, to rely on this case law for the district court to reject Pierce in the Fourth Circuit and citing a case that does not stand for that proposition, rather stands for the proposition that Pierce should apply in the Fourth Circuit, is an error of law. And if this court affirms the district court's rejection of Pierce, it will be putting this court out on an island.
I'm sorry, the district court's rejection of Pierce?
Correct.
Did the district court come out and say that the same transaction or occurrence can never be the basis for a Rule 60? I didn't see that.
Well, Your Honor, despite us arguing Pierce, it declined to follow Pierce, and it didn't apply Pierce.
Well, it declined to apply Pierce in the way you wanted it to apply Pierce. That doesn't necessarily mean it said Pierce was wrong. It did not say, in a case that is materially identical to Pierce, the district court, would reach a different decision. It certainly didn't say that, right?
The district court said it declined to follow Pierce, Your Honor, and the fact that it did not apply Pierce, even though through our urging, to me is a rejection of Pierce. But to my point that if this court affirmed the rejection of Pierce, this would be the only circuit court to do so, and it would put itself in tension with at least 6 of its sister courts, the 10th Circuit, who articulated Pierce, as well as the 2nd, the 5th, the 6th, the 7th, and the 11th, Your Honors.
So does your argument hinge on us finding this to be the same transaction or occurrence?
It hinges on this court finding sufficiently related facts between this case, our case here in North State Deli. You can use the transaction occurrence test in Pierce. Other courts have articulated a little bit differently. And I'm not sure that when it comes to Rule 60b-6 jurisprudence, a bright line test is necessarily the best approach. Rule 60b-6 itself is a safety valve. It should be flexible, case specific. But yes, Your Honor, you need to find sufficient commonality between this matter and North State Deli such that Rule 60b-6 relief would be appropriate. And Your Honors, I also want to emphasize the trial court's error when it held that Golden Corral was required to seek a stay. No case law has ever held that you're required to seek a stay in order to be entitled to Rule 60b-6 relief. That is simply not a proposition.
Wait, you said entitled. You mean entitled or do you mean eligible?
Correct, Your Honor.
Is anyone ever entitled to Rule 60b relief?
You're right, Your Honor, to be eligible for Rule 60b-6 relief. The closest any court comes is this court in Aikens, which held that a Rule 60b-6 movement was not entitled to Rule 60b-6 relief when they failed to take a number of steps to preserve the court's jurisdiction. And there, one of the steps that the court determined that the movement could have taken was seeking a stay pending exhaustion of administrative remedies.
Well, I don't think that the district court said it was a requirement. I think the district court simply noted it as one factor in its analysis.
Your Honor, but regardless, this factor has never been articulated. The failure to seek a stay has never been a basis for fault such that a Rule 60b-6 movement is not entitled to relief.
Well, as Judge Heidens pointed out, there wasn't simply a failure to seek a stay. There was vigorous, in the words of the district court, opposition to doing so.
Your Honor, again, we oppose a stay of discovery. We did not oppose a stay of litigation. Our mantra was to expeditiously pursue our claims and to try to seek the relief we are entitled to. Your Honors, I see my time is up.
Thank you. Mr. Hacker, we'll hear from you.
Good morning, Good morning, Your Honors. May it please the court. John Hacker for Illinois Union. The court's questions and counsel's answers, I think, demonstrate the insurmountable problem that Golden Corral has in obtaining what effectively would be Rule 60B-6 relief as a matter of law in this case. It is settled, as again I think the court's questions and I think counsel answer actually conceded, that a change in decisional law subsequent to a final judgment provides no basis for relief under Rule 60B-6, as this court recently said in the Ross case. Judge Rushing, you were on that panel, reaffirming Moses versus Joyner. What you need are other factors in addition to, on top of, supplementing the change in decisional law that establish that there are extraordinary circumstances that warrant relief based on that change in law. On top of that, a district court has a, quote, wide range of discretion in deciding whether such other circumstances, other factors exist, establishing the required extraordinary circumstances. In this case, as I understand it, Golden Corral, I think, cites essentially two other factors that it says establish extraordinary circumstances, again, as a matter of law. Because, of course, the district court has already exercised its wide range of discretion, evaluated all of the arguments that Golden Corral made, and the district court exercised its discretion to determine it was not appropriate to award such relief. So the issue here is whether it's required as a matter of law based on the factors that Golden Corral cites, and the answer is it is not. The first, I don't know which one is first in their mind, but the two of them are this Erie idea that there's this required uniformity, they say, between state and federal law, and the district court correctly rejected that. First of all, under Erie, as many courts have held, Bat's case out of the Fifth Circuit, DeWeerth, Flanders, Reamer from the Eighth Circuit, Flanders from the Seventh Circuit. It is the job of a district court to predict state law. That's what Erie is about. There's not an independent requirement that you always have, under all circumstances, uniformity between federal forum and state forum on matters of state law that sort of overrides Rule 60b-6's interest in finality. And if you think about it, it doesn't make any more sense that you would require that than you would require federal uniformity when you have federal law, when you have decisions that overturn federal law, as in the Ross case, right? In the Ross case, under federal law, Ms. Ross had been found liable for $160 million in monetary relief that the Supreme Court later said, and this court, affirmed that judgment. The Supreme Court later said that's not permissible. She can't be held liable under federal law for that under the subsequent decision. And this court said in Ross that Rule 60b-6 relief was not appropriate under those circumstances.
So the flip side, it just occurs to me, I don't know the answer to this question. Have you looked into what the answer to this in North Carolina state court would be? Like if the North Carolina under North Carolina law, if the North Carolina Supreme Court issues a decision that unsettles what a lot of people thought was the law, can people reopen final judgments in North Carolina state court?
That's a fantastic question, Judge Heitens, and to be honest, I have not looked at that. I will certainly look at it after the argument and see what the answer is.
It just literally occurred to me now. So.
Yeah, no, it's an interesting question, but of course, we are governed here by federal rule 60b-6, although it would at least be certainly interesting to find out the answer to that.
Well, because if the answer is no, that would pretty much obliterate the Erie argument.
I mean, yes, but I don't think there's.
I know that you don't think the Erie argument's right anyway.
Right. It's already lying in ashes, so that would only pour more water over the already destroyed argument, I think. But the other argument that I think they spend more time in, and I don't know whether they believe in it more, but they certainly spend more time on, is this idea that it arises out of the same event, which traces back to the Pierce case in the 10th Circuit. And as the court's questions suggest, I think the court understands at least the reasons the district court was correct in rejecting that. The first point is, just to be clear, this court has not adopted any version of that test. And it's not obvious that it should exist for the reasons I don't need to go into, because I don't think the court needs to reach that. But for the dissent,
So just to clear, you think, I'm happy to listen to your argument about why we shouldn't adopt it at all, but there's no reason we would have to decide that question.
100%, not at all. And I'm not even going to go into. I just want to point out that the dissent in Pierce has a very effective argument for why it actually doesn't make sense as its own sort of independent, extraordinary circumstance for warranting relief. But no decision of this court has adopted it. But the decisions of courts that have, the few courts that have, including the 10th and the Second Circuit, have adopted versions of this, plainly don't apply because they're clearly talking about, both on their facts and the logic of the cases, a situation where you've got two parties that are asserting tort claims arising out of the exact same tort, the same injury. It's never been applied to my knowledge, and I think counsel conceded in answer to Judge Hyten's question, in any contract case, certainly not when you have separate contracts with separate insureds, with separate or different language. I mean, we're not resisting the idea that the core language is material the same, but there's various things that go into contracts, as the court is aware, when you're construing particular language, in the context of the full contract. So the fact that the same words appear in different contracts absolutely can matter, and the contracts are being asserted in different factual circumstances under different, in this case would be the same government orders in North Carolina, but certainly different factual scenarios, factual circumstances of the losses that are asserted by the insured. So we've never had a case applying it under those circumstances. And what you have are, in Pierce, as Judge Rushing pointed out, it's literally the exact same auto accident. You have effectively the same thing in the terrorist attacks cases where you have the same tort, the same terrorist incident destroying the World Trade Center, and you've got two sets of plaintiffs that, just by a happenstance of timing, as Judge Rushing pointed out, they weren't able to consolidate their cases at the right time. But the court said specifically they should have been, but for the timing. They would have been consolidated, and there wouldn't have been any different treatment at all, and the mini en banc procedure wouldn't have led to those, the different outcomes. So as I think Judge Hyten's put it, the Second Circuit was essentially saying, my bad, our bad, in having done that. And so we can correct that. That was, in that court's view, a sufficiently extraordinary circumstance. We clearly.
Can I give you the hardest typo I've been able to come up with in the contracts context? So imagine a company, it could be these plaintiffs, it doesn't matter. So they basically have two types of COVID losses. They have COVID losses from the initial pandemic, the initial shutdowns in like March and April of 2020. And so they submit a claim to their insurer under their 2020 policy. And then they get shut down again because of the Delta variant in early 2021. And they submit the same company submits the same claim to the same insurance company. But because, the 2020 claim goes to final judgment and they lose, the 2021 claim is still pending when this intervening decision happens. How do you think a court would analyze that situation? So now we've taken out different parties and we've taken out different contracts. It's literally the same policy, the same insurer, the same plaintiff, the same defendant. The legal theories are exactly the same, and the only variation is that the initial shutdown claim has gone to final judgment and the Delta variant claim hasn't.
So that is one I did anticipate, unlike your last question, under the North Carolina state law. And I think the answer is, the first answer is the answer appellate courts always hate to hear from lawyers, which is that's a different case that's not presented here in the most critical way. And I don't think the answer to that one would illuminate anything about this case. I do think there would be a very good argument by the insurer under those circumstances that you would not reopen that prior judgment. That does present this question whether this court would adopt this kind of principle, the principle of law stated in Pierce and applied in terrorist attacks to the same, it's literally the same, it would be the same transaction if you treat the transaction as the same contract. But there's no particular logical reason why that would itself create an extraordinary circumstance, because you've got a prior judgment.
So the material differences between that case and this one are, just, I want to make sure I understand. You think the reason, you start off by saying that case is not this case, and it's not just not this case in a trivial way, but it's not this case in a material way.
Right.
So the material reasons that situation is different than this one are what?
Well, because, I mean, and I think they are material in that you have different policies, right?
So literally a different contract.
Literally different contract, and not just literally different contracts. This, I guess, would be sort of not fighting the hypothetical, but adjusting it, because insurance policies often have different, sometimes you have form contracts that are like literally the same, but there's almost always endorsements and things that actually make them meaningfully different, or you have to construe the language in light of various endorsements. And you see this in opinions all over the COVID coverage law as to whether or not the existence, for example, of a virus exclusion, which we have here, tells you something meaningful about the direct physical loss or damage language. And courts and litigants make various arguments about that. And this indeed is exactly a difference we have between this case and North State Deli, right? Whether that tells you something meaningful about direct physical loss or not is something that would have to be litigated, but you wouldn't just apply North State Deli for sure and say we have the same outcome. You would both have to sort of rethink or reanalyze the direct physical loss language, but then also separately, of course, apply the virus exclusion. Then you also have different factual circumstances, Judge Heitens, that may be somewhat minimized by the fact that you're talking about just a shutdown order, and the argument is that the same shutdown order applies to everybody. But in many coverage cases, the insured is making an argument about the way in which their property was affected, the reasons that they had to shut down. Was it from lack of customer demand, lack of access to the facilities, government order? What did the government order require? So you're going to have different factual scenarios as well. And those would be, some of those may be actually true in the same, even when you have the same policy and the same insured, there may be different facts that would be relevant. So that's why I wouldn't concede that even that situation would trigger that same event circumstance. But here again, for all of these reasons and more we could discuss at great length, this is not at all in any sense the same event in the sense that the Pierce case was talking about. The last point I would make, Your Honors, is on this question of Golden Corral's litigation choices, and I think Golden Corral is sort of arguing it backwards. The point, and I think one of Your Honors' questions got to this, the point of the fact that they didn't even try to seek a stay, and to the contrary, tried to accelerate and get to a result as quickly as possible, which is perfectly understandable. Nobody's criticizing them for that. But indeed, that shows why the case is not an extraordinary one. That's just the normal course of events. Litigants make decisions like that. It might be a little bit unusual to try to push forward like they did, but it's not outside the norm in any sense. And so the fact that they didn't do that just shows why this is the kind of case that's going to come up all the time. They might have a better case for Rule 60B relief if they had sought a stay and had tried to do everything to wrap themselves under North State Deli.
Filed a motion to remand, asked for stay, tried to get this case back to state court.
Right, all of those kinds of devices they could have tried. Then they might have, they would have, as they say, only a better case for 60B 6 relief, because they would say, look, we tried to do everything we could, it didn't work out.
The defendants dragged us into federal court. It was over our kicking and screaming objections. We insisted from the beginning, this is a question of state law. I need the state court to answer.
Under those circumstances, again, they would have a better claim for 60B relief. But even under those circumstances, you've got courts like Flanders and Batts, were situations where parties did seek stays, did try to do that kind of thing, and the courts in those cases said even that wasn't enough to warrant 60B relief to overcome the profound and fundamental interest in finality that underlies Rule 60B 6, or Rule 60B generally, and Rule 60B 6 in particular. The reason that the courts have been so strict in requiring extraordinary circumstances and respecting and deferring to the exercise of discretion of the district courts who are closest to the case in determining whether or not that such relief is warranted. Here, the district court determined based on a complete and full analysis, and back to I think it was Judge Rushing or Judge Heiden's questions about whether the court addressed the Pierce case. The court didn't reject Pierce categorically. What the court was saying is, I'm not going to adopt Pierce because it's not the same event situation. The Fourth Circuit hasn't adopted that rule, and I'm not going to apply that principle here. But even if the court had said, I disagree with the Pierce case and I don't want to follow it, there's no requirement that a district court follow an out-of-state decision that this court has not yet adopted. That would not in itself be an error of law, and certainly wouldn't be an error that requires the court as a matter of law to find that there wasn't abuse of discretion under these circumstances. The court acted within its discretion. It determined that Rule 60B 6 relief was not warranted because Golden Corral had not demonstrated the kind of extraordinary circumstances required for such relief. If the court has no further questions, we will submit. Thank you, Your Honors.
Thank you. Mr. Hartzell, you have some rebuttal time.
Your Honors, I'd like to make a few brief points. First, to Judge Hyten's point about remand, we had no basis to remand. There is undoubtedly complete diversity of jurisdiction here, or diversity of citizenship, pardon me, and there's no requirement for us to try to take futile actions in order to preserve our Rule 60b-6 rights. The second point I'd like to make is to push back on Illinois Union's contention about Erie in this case. Right? There is lines of case law saying that the Rule 60b-6 does not apply even when a court makes a bad Erie guess. But here we have more than a mere bad Erie guess. We have divergence results emanating from the same event with outcome-determined principle based upon whether one case proceeded in state court and one case proceeded in federal court. I'd also like to point out that Judge Hines went on about the identity of contract and the identity of parties in his hypothetical about a potentially stronger Rule 60b-6 case. But I would point Your Honor's attention back to the terrorist attacks case in the Second Circuit, when there we had multiple defendants, multiple theories of liability. So we had this wide-reaching circumstances that we have here. And still in that court, or in that case, the Second Circuit stated that it was, that the logic of peers should apply regardless of the intricate facts.
But they also said it's partly because we screwed this up and it was our fault and we're undoing our own screw-up. You just, I mean, you're asking us to just ignore that part of the Second Circuit's decision.
No, Your Honor, I'm asking you to look at the Second Circuit's opinion, recognize its application of peers, and view that in the light of other circuit courts' opinions, which have held, like I've previously pointed, the Blue Diamond Coal, that when this Erie principle is violated and forum choice is outcome determinative, that creates greater strength, and this Rule 60b-6 rule should apply with even greater force. If Your Honor doesn't have any questions, I'll sit down.
All right.
That's it. Thank you. We thank you both for your arguments today. We will descend and greet counsel and then proceed to our next case.
Good morning, and may it please the court. Andy Weiner for Catherine Roast. I'm here with my colleague, Mike Walkus. We are here on Ms. Rosa's request for innocent spouse relief under Section 2015F with respect to joint and several liability arising out of erroneous refund of tax on underpayment interest as well as the interest accruing on the erroneous refund of tax. And the government, Ms. Rosa submitted her request at the administrative level. That was denied for a gatekeeping issue, a technical detail of whether or not the erroneous refund constituted a tax underpayment. The tax court as well agreed on that on the basis of the fact that this was not a erroneous rebate refund. We would submit that the rebate, non-rebate distinction here is a total red herring. It has no bearing on
It's one
whether.
that the tax court and the IRS seems really committed to trying to make happen, no matter how many times courts tell them they're not going to do that. I just read all these cases where they argue this distinction really matters, and there's case after case after case where the courts are like, no, no, no. Where does this, like, why are they, what is your sense of why they're trying so hard to make this distinction happen?
I would say that, honestly, I think it's probably the product of the fact that this is, in this particular area of case law, we've got erroneous refunds. This is the case law that they look to, and so then they try to square their argument with that case law. I do think that that case law, though, answers a categorically different question.
Which is how the IRS has to go about proceeding.
Correct.
Okay.
Yeah, and the question here is whether or not you have an unpaid tax. You look to, it's a question of statutory interpretation. We start with 6015. 6015 provides relief, equitable relief. It's a catch-all type of relief from joint and several liability, and it applies to any deficiency or unpaid tax. Now, going through what constitutes an unpaid tax. Well, the reason why rebate refunds have no bearing on it is rebate refunds refer to what is a rebate. And a rebate is a component of what constitutes a deficiency under Section 6211. So if you don't have a rebate, you arguably don't have a deficiency. Makes sense. However, that's as far as that logic will take you. A deficiency does not capture all taxes. And in fact, if you look at the definition of a deficiency under 6211, you will see that deficiency only applies to Subtitle A and Subtitle B of the Internal Revenue Code. That would be the income tax and estate and gift tax. But there are lots of other subtitles in the Internal Revenue Code, and there are lots of other taxes, and specifically taxes with respect to interest. Why? Because Congress has told us that underpayment interest specifically is a tax. And so so I would suggest we submit that that whole line of reasoning is beside the point.
So in your view, is this erroneous refund, is this a new tax liability that has emerged, or is this reviving an old tax liability? And does it matter?
I don't know if it matters, but I would submit that it's more of a reviving an old tax liability. Why do I say that? Because tax liability is imposed by statute. It's imposed by the terms of the Internal Revenue Code. And when you pay your tax, which you are required to do when your tax is due and without any form of procedure such as an assessment, when you pay your tax and you satisfy the liability that's determined under the Internal Revenue Code, when the IRS makes a determination, erroneous or not, to refund a portion of that, that means that your tax is no longer satisfied. It is no longer paid. And so therefore, it sort of revives the tax liability. The liability is determined by the terms of the Internal Revenue Code. The erroneous refund, based on a substantive determination by the IRS, means that you now have an outstanding liability because the code requires you to pay more than what you actually did. So that's why I would call it a revival of your tax liability. But getting to what I do think that the proper construction or the proper analysis of this particular issue is whether there's been a substantive recalculation, as this court put it in Singleton, of a item of tax. This court said substantive recalculation. The Sixth Circuit said deliberate. The Seventh Circuit in O'Brien said a reevaluation. But in the end of the day, the question is whether the IRS has made a determination that you have overpaid a particular item and returned that item to you. If they decide that that is incorrect and that that refund was erroneous, so be it. But that means that you owe a tax. You owe an amount that's been dictated by the Internal Revenue Code, and you have underpaid that amount. And that is the situation that my client finds herself in today. Her husband submitted a claim for refund saying that he had that they, because it was a joint return, had overpaid the interest that was due on a settlement based on tax years 81 through 82 and 85 and 86. That was initially denied, and then the IRS changed its mind, said, you know what, you're right, you're entitled to this refund of interest. The refund was made, and then the IRS changed its mind and brought in action under 7405. All of that the government is entitled to do. The question here, however, is whether my client, who is the innocent spouse, who had no idea that the refund claim was submitted.
She claims.
She claims. Fair enough. We would love to be able to get to the merits of this case. But in order to do that, we need to obviously make sure that we are eligible under the terms of the code. And because this is an unpaid tax, we squarely fit within those terms.
Can I just make sure that I understand? So really what you want is for the commissioner to decide whether to do this, because even assuming that you win this issue here, and even assuming you win the issue before the tax court, that just makes her potentially eligible for this, right?
Correct.
And are there published regulations or guidance or standard about when the commissioner will or won't exercise their discretion to actually grant this kind of relief?
Yeah, there's a revenue procedure under, I think it's 2013-34, although that's off the top of my head.
But there's sort of, like, once we determine that you're in the eligibility bucket, there's sort of guided discretion about whether we're actually going to do this?
Yeah, it's a fairly extensive analysis of here are 6 factors that you should consider. It's an all facts and circumstances test as sort of equitable, catch-all provisions tend to apply, but then that because the IRS has to deal with 180 million filers every year and aims for consistency, the IRS has put out publication that tries to bring some discipline to that analysis. And what we want to do is to get to that analysis. And I understand that the government considers that, we've made allegations and we haven't proven them. Our request here is a reversal of the tax court's decision to remand for further proceedings so that we can actually prove the equitable.
So one of the things that would have to happen on remand right now is to try to disaggregate this, I want to make sure I have this right, this over and underpayment interest issue, because you now concede that at least some of that does not, you concede that one of those does not qualify. At least now you concede that one of those does not qualify, right?
Correct. However, I would say this.
I want to clarify which one it is. You claim that overpayment, you agree with the government now, right? That overpayment interest is not a tax. Right?
Overpayment
When
interest.
the government owes you money that they don't pay, and then they start to accrue interest on the money they have not paid you. That's not a tax you previously owed and now are getting refunded. That's the government paying interest on money it owes the taxpayer, right?
Yeah, so to draw a simple distinction, the underpayment interest is interest that accrues on a liability that you have to
Right.
the government. The overpayment interest
So when
is
I file my taxes and it turns out I didn't pay all the tax I should have, that's underpayment interest, right?
That's underpayment interest.
And is it-
Overpayment, yeah, I'm sorry.
Is your evidence on which parts of the refund were underpayment interest and which parts were overpayment interest and all that, your evidence on that is the Pelican Declaration, as I understand it, right? This IRS employee in 1997, when all of this litigation was originally, or part of it was originally happening, he submitted a pretty detailed declaration specifying which dollar amounts were underpayment interest, which were overpayment interest, and the new and old method of calculating them. So you submitted that to the tax court, right?
Yeah, and that is, so there are two things that we cite too in terms of the numbers that you'll see on page 6 of our opening brief. We cite to that declaration that you just referred to, Your Honor. We also cite to the government's complaint in the 7405 case. I would say there's an interesting addendum to
And
this.
just so again, this is just a framing question. And the tax court didn't reach any of that because the tax court said none of this matters because none of it qualifies.
Correct.
Okay.
And the government on appeal says it's impossible to discern which amounts are which, but Mr. Pelican seems to have done that.
Yes. What the government is saying in its argument is that there are kind of two ways that you could have computed interest here. It's a bit of a detailed answer, but I think it's worth going into. You have underpayment interest that accrued in years 81 through 83. You have overpayment interest that accrued in 85 and 86. And then you have a settlement of all of the years in 91. The way that the government framed its case in the 7405 action is to say that underpayment interest and overpayment interest both accrued, and then we netted them out in 1991. That's one way of doing it, and that's the way that they say was correct. That was the quote-unquote old method. The new method was to net them out as of when the overpayment interest, when the overpayments were made in 85 and 86. You get to the same result in terms of the ultimate number, but those underpayment and overpayment interest figures actually change, because there you have, because you're netting the overpayments against the underpayments when the overpayments happen, none of the overpayment interest accrues. So the overpayment interest would be zero according to the alternative way of doing it, and then you just have underpayment interest. So the government's argument actually helps us in this case, because we have taken the greatest division of, the way that the numbers reflect on page 6 of our brief is you have about $1 million of underpayment interest and about $500,000 of overpayment interest. But if you netted them in, and that's netting them in 1991, if you netted them when the overpayments were made, you would have zero overpayment interest, and you would have all underpayment interest, $1.5 million of underpayment interest. And so that suggests that she should be entitled to full relief from her liability, or at least eligible for full relief from this liability. And so that is something that we'll address when we go back. But to get to Judge Hayton's point, that's not something that we ever got to because the court never reached the merits. This was a motion to dismiss that the court refashioned as a motion for summary judgment on the pleadings and decided the issue that Mrs. Rosa was ineligible as a matter of law.
And other than, again, it's global holding that you're just completely out of luck. Did the tax court reach this interest on interest question and about whether that?
No, the tax court didn't reach that particular issue. Let me be clear, though. We did claim relief from the full amount of the liability. So we have preserved that issue. And there,
But it's just an issue the tax court has never passed on.
the issue is the tax court has not passed on, made no mention of it in its judgment or in its decision rather. And we submit that you should treat the interest that accrues on an erroneous refund the same as you treat underpayment interest, because they are functionally equivalent in every way. They use the same rates. They both apply by definition. 6602 talks about interest that accrues on a tax liability. So they both accrue on a tax liability. They are both obviously in Title 26, the Internal Revenue Code, and they are both subject to the same collection authorities by the Internal Revenue Service. And so we would say that they are functionally equivalent, and therefore that it would also make no sense for her to be eligible for relief from a liability, but the interest that accrues on that liability would not be eligible for relief. So she should be, that as well is an unpaid tax for all of the reasons that I just went through, which apply equally to underpayment interest as apply to the 6602, the neighboring provision in the Internal Revenue Code, the interest that accrues on an erroneous refund.
Can we go back to your citation of the O'Brien case? So there, as I read the case, the court held that the unjust enrichment was the basis for the government's ability to file suit, and that the tax liability had been extinguished. So here, if we were to follow the same logic, the tax liability would have been extinguished and there would have been an unjust enrichment, and so a new liability that wasn't a tax.
Well, I do think that courts have been admittedly historically a little imprecise of their use of assessment and liability. Like I would cite to page 345 of that decision, as a taxpayer makes payment against a tax assessment, the assessment is extinguished. That is correct. And that is what that entire line of case law, if you look at O'Brien, Bilzerian, Williams, they all stand for this proposition that when a taxpayer pays a tax and there's an erroneous refund, the IRS can't use its administrative collection authorities because the assessment has been extinguished. And an assessment is an incredibly important procedural mechanism in the Internal Revenue Code, because what does an assessment do? It turns on the IRS's collection authorities. And so if you make a payment and the assessment is extinguished, the point of that line of cases is the IRS, you need to make another assessment before you can exercise collection authorities. That means submit a lien, impose a levy. In all of those cases where the IRS is lost, the IRS did not go to the trouble of making another supplemental assessment. The IRS can do that. In fact, the IRS did that in the context, and I say that my time is up, if I could just finish my answer.
Of course.
The IRS did that in Ideal Realty. Why is Ideal Realty a really important case here? It is because the IRS entered into a settlement, made an erroneous refund of underpayment interest, then made a supplemental assessment and collected it. The court said that the court was dealing with an ancillary procedure. It wasn't answering the question as to whether it was an unpaid tax, but the court affirmed the IRS's collection authority there, and that's what the IRS did. And in this case, the IRS is taking the exact opposite tact. And so it's an example of doing exactly what the IRS says it doesn't have to do.
Thank you, counsel.
Thank you.
We'll hear from you on rebuttal. Let's hear from the commissioner's attorney.
May it please the court, Robert Bramman for the Commissioner of Internal Revenue. Mrs. LaRosa seeks relief under 6015F, which is restricted for liabilities arising for an unpaid tax or deficiency. It may seem like an arcane point. What's the big deal? She's got a liability to the United States. What difference does it make whether it's an unpaid tax or something else having to do with the IRS? But
Before you get into that, can I just ask you two questions that are just rattling around in my head?
Of course.
Why did it take 20 years to follow up in a 1998 judgment?
I sure don't have an answer for that. The IRS sometimes gets criticized for collecting too aggressively, sometimes for not collecting aggressively enough. I can't answer.
So I guess the only thing I'll say is, but to the extent there's this air that like there's this air in your brief that this person is trying to fight a tax that was imposed so long ago. He's like, well, I mean, part of the reason it's so long ago is because the IRS sat on this for 20 years.
Well,
which is not her fault.
We sat on it for 20 years, but we did obtain a judgment from the district court.
Sure.
And the
Okay,
judgment's
and then the
recorded.
other thing-
Often that's what does, the collection work for the IRS.
But
a tax
you
lien
didn't
or
have
a
to wait
judgment.
20 years to realize it wasn't doing the collection work here.
Agreed.
Okay. So the other question is, when I just read the tax court's opinion, it just drives me crazy. On what plausible basis did the IRS argue that tax court lacked jurisdiction? That just seems like such a flagrant misuse of the word jurisdiction. I was genuinely flummoxed by it.
I can't answer that either because, well, that sort of fell out of the equation. We're not contending that it didn't have jurisdiction.
Thank you.
Okay.
while we're asking questions.
That's what we're here for.
So if the La Rosas owed underpayment interest on 1981 and 1982, and they didn't pay it, that would be an unpaid tax, right?
Correct.
Now, here they paid it, and then they filed for a refund for part of that back. And the IRS gave part of that underpayment interest back. So they gave part of the tax back. And then the IRS changed its mind and said, no, we were wrong. You do owe that to us. You do owe part of that same money. So it was an unpaid tax. They asked for a refund. They got a partial refund. And now the IRS wants that back. Why is it not still a tax? Why is it not still an unpaid tax?
Because it was paid.
Right.
It was
But
paid
there's plenty of courts saying you pay a tax, and then the government can revive it when they give you the money back erroneously, right? Now you still have tax money that the IRS says belongs to it.
The consensus of courts is that payment of tax extinguishes the tax, except for the very narrow exception of when the IRS issues a refund, which is a rebate refund. And this was not.
You said the
But
consensus.
why? That's like so tricky. Like, that's just, I mean, the IRS can say, this is a tax, you owe us a tax, but if you pay it and we give it back to you, now it's not a tax, right? And you couldn't, I mean, that's not at all what 6601 says, right? 6601 says underpayment interest is a tax for all. When you read tax in the code, that includes underpayment interest in every section except the section about deficiency procedures,
Well,
right? And we're not in a section about deficiency procedures, right?
We are.
We're in 6015.
Right, 6015 is the innocent spouse relief, yes.
Right,
But-
and that's not in subchapter B of chapter 63.
No, but we still have to decide whether it's an unpaid tax or not,
Right,
and we have to.
but
we have to
6601
honor all
tells me
those-
that when I read tax, that includes underpayment interest. So when I read unpaid tax in 6015, that includes underpayment interest. Right, that's just reading the two statutory provisions together.
Okay. Let me say this, I mean, some of the confusion, I guess, I would say the government caused in the 1990s, in these earlier cases, the government was arguing in the 1990s that when it gave an erroneous refund, even if the tax had been paid and liability extinguished, the assessment lived on as a bookkeeping error, a bookkeeping entry. And the government could continue to use administrative tools to collect on the assessment because it was still there. And the court said, no, 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 starting with Wilkes in the Fifth Circuit in 1991, and then O'Brien is a very strong opinion in that sense. And then a number of courts followed it, and the government eventually had to change its position and accept the consensus of the courts that once the tax is paid, it's extinguished, and then if government gives the money back, it's not a tax liability.
Well, this is all talking about the context of the procedures, right? All of these cases arise in the context of how the IRS can go about collecting the money. Do they have to issue a new assessment? Can they proceed under one section or a different section, right?
Yes, and the IRS needs to know what's the right way to go.
Right.
And the current settled law is, once the tax is paid, it's extinguished, and if the IRS gives money back, it has to determine whether the refund was a rebate refund or a non-rebate refund.
You keep saying it's settled law, and as I said to your friend on the other side, I guess I read a whole bunch of cases in preparing for this argument in which the IRS keeps insisting that this distinction is really important, it really matters, and courts keep saying, stop trying to make this distinction happen, it doesn't apply here.
Wonder what cases you're seeing that out of, because
Well, I mean, I guess I could start with the statutory text. As Judge Rushing already walked you through, I have no idea where that distinction has anything to do with the statutory text. In this context.
It comes out of, it's the,
Singleton is an opinion that I think pretty clearly says, stop trying to make this happen.
the court was not sure whether it was going to accept the rebate.
I don't read
distinction.
Singleton as saying the court was unsure. I read the court as saying this distinction makes no sense, but even arguably assuming that it had some relevance, you still lose. That's not, I think the Singleton Court made pretty clear it was not buying this distinction.
Okay, well, it's certainly been accepted by the Seventh Circuit and the First Circuit and the Fifth Circuit, and some other circuits have said that you did accept it in Singleton. The Federal Circuit and the Second Circuit have lumped Singleton in with the other cases as accepting the rebate, non-rebate distinction.
What about the Sixth Circuit in Greer?
Fascinating
You know,
case.
they didn't dispense with rebate, non-rebate, but the analysis seemed to be, look, that distinction is not really determinative here. It's not relevant. We're not going to fight the distinction, but in the context of that case, it didn't matter because the court could apply the statutory language and they could understand what was going on. And I found the analysis there, it's not the same section that we're talking about, but I found it persuasive in looking at what is a tax amount and how can we tell that it's related, right? You apply for a refund of your taxes and you get that money back. The court was drawing a line there and saying that's pretty clearly tax amounts, whether the IRS considers it rebate, non-rebate, or, you know, any other adjective.
I found that a fascinating case. I thought the court did a terrific job of tracing out the non-rebate distinction and the fact that taxes are considered extinguished by payment. But it was such an unusual set of facts where, in case anyone has forgotten, the taxpayer paid tax, asked for a refund, went to court because he was impatient that the issue was being disputed in the tax court and it was taking too long. So the district court ordered a refund, or dismissed the case and ordered the refund paid back. The Sixth Circuit finally had to say that it wasn't sure that it could consider that payment an erroneous refund. I mean, it wasn't the IRS paying it by mistake. It was court ordered. It was ordered by court to payment. So the Sixth Circuit went out of its way to acknowledge this body of law and take its case out of that body of law under extremely unique circumstances. I don't think Catherine LaRosa's case comes anywhere near that level of uniqueness.
But why is there analysis of what is a tax amount and what is, you know, directly traced to payment of taxes and a tax refund? Why is that not applicable here? I understand why one of the reasons they gave, which is that they couldn't really say it was erroneous because a court ordered it, why that doesn't apply. But the rest seemed pretty on point. And, you know, and they went out of their way to say, we're not questioning whether this makes it a rebate or a non-rebate, but this is a tax amount clearly, and it's directly related to the request to receive a refund of tax amounts. It's not like the IRS, you know, accidentally sent them someone else's refund, right? Well, it's the same thing here.
Right.
So why is that not persuasive and applicable here? Why shouldn't we adopt Greer's perspective on what is a tax amount, I think is the word they use?
I think if you decide that this erroneous refund was an amount of tax, it will throw into disarray the IRS's ability to know how to proceed in the next time it issues an erroneous refund, and it will. That it won't be able to use this, you know, this construct of what is a rebate refund and what is a non-rebate refund. Should the IRS in this case have tried to collect this erroneous refund with supplemental assessment and administrative collection tools? If the court's decision suggests that it should, it will throw into disarray what we now think are relatively settled rules about how the IRS should proceed.
Do you agree that the Pelican Declaration sets out what is the underpayment interest and the overpayment interest?
It sets out the alternative ways that the matter was
But
computed.
also the specific amounts, like how much of the refund is attributable to underpayment interest and overpayment interest?
I don't quarrel with the Pelican Declaration.
Okay, so you agree it's possible to disaggregate those two?
I think an accountant maybe could disaggregate, but maybe there
And
are.
has in fact already
Maybe
done
there
it.
are multiple ways to disaggregate. It certainly wasn't presented a proposal wasn't presented to the tax court for how to do it.
But the tax court had this declaration, yes?
Yes. But as, I tried to explain, there are alternative ways to figure it out. There's no way, once the erroneous refund amount could be conceptualized as some amount of overpayment interest and some amount of underpayment interest, there are alternative formulations. It doesn't,
Sure, the government might, if you end up in front of the tax court, not just accept the Pelican Declaration. You could try to argue that you should do it a different way. Is that the idea?
for the district court, it was good enough to decide that,
No, sure, the tax court didn't think any of this mattered because the tax court thought none of this is applicable. But if this court were to say some of it is applicable, then someone, either this court or the tax court, would have to try to decide. That's all.
yes, yes, the tax court would have to try to dig in and figure out whether it made sense to do it some other way. Two things I wanted to point out. I wanted to challenge my friend on the significance of the Ideal Realty case. Here's why the Ideal Realty case is not really ideal precedent. When a taxpayer pays a tax and sues for a refund, the court will have to really dig in and figure out whether they owed the tax or were due a refund. In the Ideal Realty case, the IRS was threatening to collect administratively, and the taxpayer ran into district court and asked for an injunction. Between the Anti-Injunction Act, it's 7421 of the Internal Revenue Code, and a Supreme Court exception, in order to get an injunction on collection, of course, the record might not be as well developed in an injunction suit. But in order to get an injunction, the taxpayer has to show, under no circumstances can the government prevail. It doesn't really require the district court or the Court of Appeals to dig in and figure out really what happened. And that was the status of the Ideal Realty case. One other thing, the cases say that a rebate refund requires a substantive recalculation of tax. I say here there was no amount of tax recalculated. The La Rosa's taxes for 1981, 2, and 3 were settled and recorded in a stipulated decision of the tax court. And the IRS's recomputation of interest didn't touch those tax amounts. My friend added a word to the formulation. He said the cases permit a rebate refund for a substantive recalculation of an item of tax, conceptualizing interest as an item of tax. So far, none of the cases deal solely with interest. All require, or the most common formulation of this test for what's a rebate is they require a substantive recalculation of tax.
Would that be then the distinction between a liability and an assessment?
No.
So your colleague on the other side, I think, urges us to distinguish between the two. And it's my understanding that you are reading the two as the same. Is that right? In other words, if we were to find that what is at issue here is, in other words, does it matter whether this is a liability, whether this is an assessment or liability for purposes of our analysis?
No, we would say at this point that they're one and the same. The full payment extinguished the assessment and the liability both.
And so what you're saying that, in fact, neither is an issue, neither an assessment nor a liability, that this is a wholly different thing.
Right, this is not a tax assessment or a tax liability. It's a liability for unjust enrichment. If there are no more questions, I'll stop.
Okay. Thank you, counsel. Some time left on rebuttal.
Just one point that I'd like to close with. I just want to respond to the argument that that potentially the analysis that Mrs. LaRosa is offering here as to why there's an unpaid tax would somehow throw tax administration into disarray. I want to disagree with that and walk the court through what I believe is relatively established, and what we are trying to do here is just to apply the rules as relatively established. In Singleton, this court said there are two ways to collect an erroneous refund. The government can bring an action under 7405. That is one of the ways, and that is the way that it did so here with respect to the erroneous payment of underpayment interest. In addition, the IRS can make a supplemental assessment and to collect administratively. And that is what the government did, that is what the IRS did with respect to an erroneous refund of underpayment interest, same as here, in Ideal Realty. So between this case and that case, you have the government exercising both of its options. And here, but in regardless of which option they choose, the nature of the underlying liability is the same. It is an unpaid tax. And how do we know? Well, we've gone over a number of reasons in the opening colloquy, but one of them that I would add is when you make a supplemental assessment, in order for the IRS to make a supplemental assessment, there must be a tax that the IRS is assessing. There's got to be a tax liability. The IRS can't assess nothing. It can't make up debts that the taxpayers are obligated to pay. It must find that there is a tax owed under the Internal Revenue Code. And so therefore, by the IRS's own practice, by the terms of the Internal Revenue Code, by the decision law, there is an unpaid tax here. And Mrs. LaRocha should be eligible for innocent spouse relief. And this case go down for her to be able to substantiate that. With that, I thank you for your honor's time, and we submit.
Thank you. We'll come down and greet counsel and move to our last case. Ethicon Endosurgery. Mr. Wyndham, whenever you're ready.
May it please the court, my name is Hunter Wyndham, and I represent Mr. Eichen, the appellant in this case. Mr. Eichen asks that the court reverse the district court's order granting the Ethicon entity summary judgment and denying his motion to extend the expert disclosure deadline for two reasons. First, the district court fundamentally misunderstood the factual record before it and abused its discretion in that way. It thought that Mr. Eichen actually knew the identity of the product in December of 2023, 4 months before the deadline. Also, the district court misread sort of how long this case was sort of before it. And the second point is that the district court looked under Federal Rule of Civil Procedure 16 instead of the more specific rule, Rule 6, in analyzing whether to grant Mr. Eichen's motion to extend his expert deadline.
Can I briefly ask you about the first one? How does the district court err in clearly finding that you didn't know something until a certain date when you specifically told the district court you found out about it on that very date?
So I think, Your Honor, that mistake was ultimately corrected in the papers before the district court.
So a district court is supposed to track when parties take back things they've previously represented to the district court and clearly err when they don't do that?
I think that in two places, Your Honor. I think one at JA 306 and sort of the response to the opposition from Ethicon. I think that they get into more detail on that sort of misstatement.
Okay, but, I mean, would you like me to directly quote JA 288 and what you told the district court and how it exactly mirrors exactly what the district court found that you now claim was clearly erroneous?
And Your Honor, I think that you're exactly correct. That is a misstatement, 100%. But I think there are two instances also in that response, and then also I think even in later in sort of the motion for reconsideration that was filed, I think it's very clear that Mr. Eichen's telling the court that, we did not know the exact product identity until March. In that motion to reconsider, I think Mr. Eichen says, to not allow the plaintiff any meaningful opportunity to prosecute his claim after finding out just the manufacturer's name in December would constitute a manifest injustice.
So let's assume for the sake of argument that when you knew the actual stapler somehow matters. Why in the world does knowing the exact model of the stapler have anything to do with whether you would obviously need an expert witness in this case?
I think for sure we knew from the get-go that we needed.
And you made no effort to get an expert. Like, why can't you get an expert witness before you know what the stapler is? I don't understand how you can't get an expert until you know the exact stapler.
So I think maybe that's some insider baseball as far as the experts go. In each one of these difficult products cases, trial counsel will reach out to the experts that they have that maybe they've used before, that maybe they think they're going to need. And in this case, that's what happened. Experts were contacted beforehand, and they were sort of on standby in a sense. These experts, they're not going to agree to be an expert in your case until you have certain information.
So you're representing that you have stapler-specific experts. This is the expert for this stapler model, and I have a totally different expert for a slightly different stapler model made by the same company.
Not stapler-specific models, Your Honor. But I do think that typically whenever an expert, and I think the rules sort of consider this both in Rule 26, and then I think even in sort of the district court scheduling order often, when you identify an expert, oftentimes it's sort of you accompany that with the at least initial report of the expert. And for the experts, they really can't do much at all until they know what that model number is.
Okay, great. So let me ask the next question. You obviously knew before the scheduling order deadline ran that you did not have an expert who was not going to submit an expert report on the date that expert reports were due. And you just let that deadline run without asking. It feels like this would have been a great thing to say to the district court. Dear district court, please modify the scheduling order to give us more time. But what you instead did is you just let it run.
The deadline did run, Your Honor. I do think it's important that it only ran by 20 days.
You keep using the word, okay, so now unfortunately, your brief says that over and over again. I don't understand a sane world of litigation in which only is a word that you can apply to missing a deadline by nearly 3 weeks.
Well, I think it's important to...
Only is like, it was due at 5 and I only got it in at 5:05. Only maybe is it was due on Thursday, but I got it in on Friday. I don't know any world in which it's useful in the litigation context to describe 20 days as only 20 days.
I think it's important to sort of look at sort of the context of this litigation, Your Honor. 20 days here in this litigation is a very, very short time. And oftentimes these product cases are much more difficult.
I guess what I'll tell you is that every single person who's ever worked for me and almost every person I've ever worked for would say, if you're going to miss a deadline, you have to ask for more time before you miss the deadline. It is completely unacceptable to just blow off the deadline and then ask to be excused of it later. Maybe if you had some really compelling reason, like I was hit by a bus and I was in a coma or something like that, but like you can't just miss the deadline and then when someone points out that you missed the deadline, say, well, I'm sorry, I was having a hard time and I just didn't get to it.
But, Your Honor, I think that's the purpose of sort of the rules that we're looking at here. It's not just, you missed a deadline, that's it. Under either standard you look at, there's going to be a factor analysis. And I think that for sure the reason for that delay, that is one of those factors. It kind of depends which rule you fall under, whether it's a little bit more or a little less important. But it's ultimately a factor test. And I think here what it looks like is the district court sort of took that one factor and just kind of ran with it. Instead of looking at some of the other factors. And I think that on remand, if the district court knew, or just if it's obvious before this court, based on, hey, it's just 20 days, they really actually didn't know what the product number was. Now they know that both the manufacturer and the product number for the first time. And I really don't think there was any real way of knowing at that point in time what the product number was. Discovery had been issued.
At what point in time was there no way of knowing?
I think that until March 18th of 2024, Your Honor, Mr. Eichen really...
So January is when the depositions happened, right? When the doctor who actually used the stapler sat in front of counsel and answered any questions that they had for him.
And I don't think at the doctor's depositions, I think it was possible for sure that maybe at that point it could have been.
So it's not that there was no way to know before March 18th. You could have found out in January.
I say possible in the sense that I think the hope was at that point, these doctors' depositions are going to clarify. I don't think that's actually what happened despite the questions being asked. At page 18 of Ethicon's brief, they talk about there was detailed testimony provided by both doctors as to several.
So you can ask a follow-up question, right, and get that specific answer if you need it. Another great opportunity might have been to file these discovery requests earlier, right? Was there any reason why Mr. Eichen couldn't ask for these responses before his deadline for product identification had already passed?
I think that he was hoping that the doctor's depositions would finally clarify it. At least that's my understanding. And then when they didn't, then he issued the discovery request. As far as those doctor's depositions, I do think those more detailed follow-up questions were asked, Your Honor. I mean, I think at J216, you look specifically, they're asking the doctors about the different staplers because there was still there was a Covidian stapler that may have been used in the surgery, and Covidian, there were several defendants that were Covidian and or Medtronic that had manufactured those. And the doctors said themselves, look, like we have several staplers in the room with us. We use the Covidian and the Ethicon staplers interchangeably. And so we don't know exactly, which stapler it was that was used. We can sort of tell you the color and kind of the curvature on it, but, we don't know the exact product
Can I
number.
just ask you to address a big picture? So the district court literally said to you in the first scheduling order, take this scheduling order seriously. This is not, I'll just quote it, is not a frivolous piece of paper idly entered, which can be cavalierly disregarded. I just get this feeling that the entire course of litigation by the plaintiff is sort of treating the district court's deadlines as sort of suggestions that should be met if it's easy to do so, but not a big deal if not.
I think that would be a mischaracterization, Your Honor. I think one thing that sort of suggests otherwise is, yes, we're on the fifth scheduling order whenever this sort of comes to a head, or all of these orders before. But at that point in time, all of the parties had agreed to a consent motion to extend the scheduling orders up until that time. Up until that
Great,
time.
you could have approached opposing counsel and asked for another consent motion instead of just blowing the deadline by 20 days.
That's a fair point, Your Honor. But I do think at this point in time, the understanding was, and I think some of the backdrop too was, finding that stapler, there's a lot of discovery that maybe did not make its way into the record because it was informal discovery. Grand Strand Regional Medical Center was the hospital where Mr. Eichen had the surgery, and they weren't actually a party to the case, but a good bit of the discovery that did take place was informal discovery to Grand Strand by the way of their attorney, Will Thomas, and they had an attorney before that. And I think that Grand Strand ultimately was the entity that the parties, especially at least Mr. Eichen, was sort of looking to for most of the information as far as, how do I figure out which exact staplers were in the room at that time? And, for whatever reason or not, there was some sort of delay and difficulty getting to Grand Strand, getting that information
Can I
from
take
them.
you to the Rule 6 versus Rule 16 question? So my understanding is that you're arguing that Rule 6 is narrower. That's your argument why 6 controls over 16, or it's part of your argument anyway?
I think that's part of the argument. I think also it's
How can that rule possibly be narrower when it begins with the words "in general"?
I think it's also just more specific in a sense, more narrow. It sort of fits.
Really, one of these rules is about scheduling orders, and one of them is not.
But I think that Rule 6 also, it's about when an act must or may be done. And I think that's exactly what we're sort of looking at here is, hey, you've got to make your expert witness disclosures, by this time. And I think that's the operative language of Rule 6. I'll give you that we're in a scheduling order. I mean, the district court has taken.
And Rule 16 is like labeled scheduling orders.
It does say scheduling order in that rule, but I also think if you look at sort of where the expert witness disclosure deadlines come from originally, they are in the more general federal rule of civil
So
procedure.
can I ask you to respond to your friends on the other side cite Professor Gensler's treatise that says Rule 6? It's not even that. Professor Gensler argues that it's not only there's a conflict and that Rule 16 beats Rule 6. Professor Gensler has an argument that your friends quote that says Rule 6 literally doesn't even apply in this situation. It would not apply even absent Rule 16. What do you say to that?
I think the professor reads a lot where there's just silence. I'll give it to the professor that whenever Rule 16 was really sort of, I think, revamped in like the 80s, that there wasn't anything said about Rule 6 and how this might apply. But I do think, when we're looking at the rules themselves, we should really look at the text of the rule as opposed to, what a professor said. And I would also say that professor, in that quote, I will give my colleagues credit, the professor said there aren't arguments to the contrary that Rule 6 should apply here instead of Rule 16. And I don't think if the court says that, Rule 6 applies to these expert witness disclosures, that means that okay, well then Rule 6 applies anywhere. I think that sort of the distinction a lot that can be made between expert
This
witness.
is how you're going to try to distinguish Nurison?
I think it's a difficult task. It's what I'm going to try to do with it. I think that here, Rule 26 sets out those initial deadlines of, hey, you've got to put your expert down at least 90 days before trial. And that's found in Rule 26. And so I think that Rule 6 sort of relates, not only is it more specific in when an act may or must be done, but I think also it sort of points more generally to the rules and to the fact that, hey, if you're going to have an expert, we know sometimes you need one. This is when you have to have it. And I think Rule 16 would, of course, still apply to several deadlines, especially anything where there's not a deadline already set under the rule. So if you've got a mediation deadline, if you've got, other sort of disclosures like Daubert motions or, dispositive motions.
Wait. So your view now is that some deadlines in a scheduling order are governed by Rule 6 and some are governed by Rule 16?
I think it's at least possible.
That just seems like a recipe for utter chaos.
I think it's at least possible, if you haven't missed that deadline yet, that Rule 16 may be the operative rule for an extension. If you have missed the deadline, then I do think that Rule 6 is probably going to be the most operative rule because it does deal with, when an act must or may not have been completed, and, now we're past that deadline.
And just to clarify, both Rule 6 and Rule 16 both require good cause, right?
They both require good cause. I think that the big distinction between Rule 6 and Rule 16 is, I think that Rule 16, I think ultimately they look at the same factors. I think that the reason for the delay, which I think is also what courts call diligence, I think that factor under Rule 16 is just a little bit more emphasis placed on it as opposed to when you're in Rule 6 land. Now, I do think that most of the cases that the other side cites, as far as, hey, look, here's another order, here's another court, sort of saying no abuse of discretion. I think a lot of those cases are factually different than Mr. Eichen's. The closest one to Mr. Eichen is the In re Lone Star case where there was a...
So can I, before you start parsing these cases that are not controlling on us, is your answer to Judge Rushing's question that you think the words good cause mean different things in Rule 6 and Rule 16?
I think that Rule 16...
I feel like this is a yes or no question. Do you think the words good cause mean different things in Rule 6 and Rule 16?
I think they mean the same thing, Your Honor. I think there's other language within Rule 6 and within Rule 16.
I just don't know where, because you make this argument that Rule 6 is, the stated assumption of your brief is that Rule 6 is a more friendly standard to you, and it's not at all clear to me textually why it's not a harder standard for you, because Rule 16 only says good cause, whereas Rule 6 says good cause and excusable neglect, and I guess sort of elementary logic to me would say if you have to satisfy X and Y, that's a more restrictive standard than saying you have to satisfy X.
I think the way that we're thinking about it, is, you do have the excusable neglect in Rule 6.
Right, but you don't even get to excusable neglect if you don't have good cause.
But I think sort of distinguishing between the standards, in Rule 16, it also has to, you have to have the judge's consent. And so I think that, here, I think that arguably the district court's already sort of ruled on it. He has not granted that, and so we would think that Rule 6 would be the more operative rule. I see my time's expired.
Thank you. We'll hear from the appellee. Appellees, plural, sorry.
Yes, Your Honor. Thank you so much. May it please the court, my name is Matt Bogan. I'm here on behalf of the Ethicon defendants. If I might just for a second start and take a lap around the track, looking at the factual conclusions that were clearly correct. The first hurdle that's thrown in the way is the language of Rule 16 that says good cause. The second hurdle that I see for my brother at bar is record page 288, paragraph 4, where they admit they knew the model number and the product ID for the stapler. I would also, as I'm going around the track in time sequence, I would next go to the December 11th, 2023 email from my law partner to the plaintiffs. And attached to it were some screens that look like this. This is at 571. Page 575 of the record has the actual product number. This is December 11th again, the date they admitted to the district court knowing about it. It has the product number for the circular staple that was used in the plaintiff's surgery. again, going a little further to the quarter mile around the track, I would get to January 11th. Dr. Baltman, who was the operating surgeon at Grand Strand Regional, he testified on January 11th, without a doubt, Judge Rushing, to your earlier questions, about the use of a circular stapler at this place where there was the leak later. There was only one circular stapler identified on December 11th in these screenshots, which was ours, the 33 millimeter, with the product ID number. And so when Dr. Baltman's testifying about a circular stapler at JA 215, 13, 14, 15, and 16, he's talking about our stapler that he used. It's correct that Codeman was still a defendant in the case, but they were not identified in the December 11th email. So there was no doubt in the questioning there of that doctor what stapler was used. It was used at this site as soon as December 11th, no doubt by January 11th. And then you go to Dr. Clatterbuck's deposition January 24th, also talking about the stapler. So those are 4 hurdles going down the track. I could go further to say that a practical point that I would make, I think Judge Curry, in a case called Kirby, made this point, and Judge Heitens, you kind of alluded to this earlier. You got an expert disclosure deadline that at JA 56, Judge Dawson says, the use of discovery, closure, and dates and deadlines for disclosure of experts are important tools for case management. Okay, so that's on the notice to counsel at the very inception point of this case. You've got the discovery disclosure deadline for experts, product ID February, March experts. Discovery doesn't close until July. So practically speaking here, and Judge Rushing, I think you hinted at this earlier, you've got other things happening at the case. Well, what happens here is after the expert disclosure deadline is missed in March, no further discovery is conducted. They served discovery in February, which we answered. Our answers weren't due until after the expert disclosure deadline.
And they served that the day after the product they were required to identify the product, right?
Correct, Your
But
Honor.
then they didn't, and the next day served discovery requests to maybe find out some answers to these questions.
That's right. The answers to the questions, they already had the information that they could have answered for
Sure.
themselves, is what I would contend. But, you know, here, they just didn't. Whether they actually knew it or whether they had the information at their access, I can't jump into their minds. But I would say, Your Honor, with respect to the discovery, yes, my point was this, Your Honor, when we served our discovery response on March 18th, we identified employees, the salespeople, Mr. Heil and Mr. DuBose, that sold these products down to Grand Strand. So they had other information. They didn't attempt to take any depositions. Again, another hurdle on the track. And another one that I would get to is very curious, and not to pick on my brother at bar who is new to the party here. JA 682 through 688 are emails. I've never seen this before, but they're internal emails among plaintiff's counsel, where after we send our discovery responses in November of 2023, they say, hey, let's file a motion to compel. And then there's emails that reemerge in April of 2024 say, hey, Bud, what about the motion to compel? And no motion to compel was ever filed. I mean, they represented to Judge Dawson they might have thought about it, but no motion to compel was ever filed in this case. So what was happening, why it was happening, I don't know. I just know they missed 2 deadlines, product ID deadline when they knew the product. They missed their expert disclosure deadline. And then after that, they didn't conduct any further discovery or take any efforts to make any motions. And I think, there's not a question in my mind about what standard applies, even though, I guess if I had to admit, the Rule 6 standard would be probably much harder for him. But Rule 16 clearly says good cause. It's in the rule, right? I don't have any doubt. You know, we've got the Nurasan case was kind of the inception point for this circuit where we start citing the KMAC case from the 8th Circuit. And kind of feeding through there are probably a dozen cases cited in our briefing, including the tally and the fault.
Can I ask you about the Nurasan case? I mean,
Sure.
Do you think that case just resolves it, or do you think, I guess I'll just tell you, I think, that there's a meaningful difference between Rule 15 and Rule 16?
Judge, that's a good question. I don't think there is, but if there is, I would cite to you the Southern versus Bischoff case, which is, it's.
Why don't you just tell me what you think the distinction is rather than tell me what some other court said they think the distinction is?
Oh, it's our court that I was citing, Your Honor, but I don't think there's a distinction at all.
But why not? Because Rule 15 actually has two questions. Like, question one is, should I let you file an amended complaint? And if I let you file an amended complaint, can that complaint survive? Whereas the question here is just, should I let you change the deadline? Those seem like, again, the case is definitely good for you. I'm not saying that I think it's it's certainly better for you than it is for them, but I'm just not sure that it actually just resolves this question.
Fair enough, and I don't mean to dodge that question. I can see a distinction being made. I don't think one exists in the case law yet. I think the answer is still the same, even if you make a distinction between a double-step process with Rule 15. But again, our circuit's decision, which is unpublished, in Southern versus Bischoff, which is cited at page 15 of our brief, it was a use of expert affidavit, Your Honor. There was a doctor in that case named Eyeline in a asbestosis case where summary judgment comes after discovery's closed. The plaintiff supplements with an expert affidavit that goes to the moment, to the question, and the court says, I'm granting summary judgment, and I'm not considering that affidavit because it was late. It was after the discovery deadline. So I think that falls squarely here. And again, I don't mean to be cavalier and not, I could make a distinction. I think what you said, Judge Heitens, is entirely
Because
reasonable.
Rule 15 expressly contemplates that you could lose a motion to dismiss and then say, please let me try to fix the thing that just led to you granting that motion. Like, Rule 15 expressly contemplates that you're allowed to do that.
Yes, Your Honor. I do think it has a little more grace in it, if I may use that word, but you still have to make it through the good cause and be diligent standard, I would think, which is the first gateway, because when the professor from Oklahoma, Gensler, he talks about occupying the field. I think Rule 16 has occupied the field, where you have to first get through that elevator bay to then get into the Rule 15 analysis, which our court does. And Judge, candidly, it's obvious that most of these cases we cite are Rule 15 cases. And I think the only one that's not is the Southern case that I extrapolated a little bit for. So, I mean, if this court is writing a decision that makes a distinction, I still think the outcome's the same, but I could buy into there being a distinction with Rule 15, but I don't think it matters. I think good cause still applies, and I can cite to the Southern example using an expert affidavit after the deadline expired to bolster why the outcome should be the same.
So if arguably either test, the district court could have applied either test, why would it be, I mean, it doesn't seem to me there would be an abuse of discretion to apply either.
No, Your Honor, I don't think so. I think, and look, candidly, reading the briefs, the parties I don't think knew what standard to apply either, but I think under either one we win. I think I've explained why, Your Honor, I think Rule 16 applies, but if you tick through the four standards of Rule 6, if that's the test that's adopted, they can't meet that either, because the first one has to do, as Judge Rushing cited, they both involve good cause, and they both involve diligence. And there is no record of diligence before this court. And I think if you go back even to JA 288, Your Honor, which is their motion to amend the schedule, which again, I know it was only 20 days late, but it was after the deadline expired. And it does.
After a motion for summary judgment.
And after a motion for summary
Which,
judgment.
that wasn't the deadline. You could still have had more discovery. The
Right.
summary judgment motion might have been early, but courts don't take kindly to requests to change the record after a motion for summary judgment.
Right, and we filed it intentionally then because they couldn't meet their burden without experts in this product case. But, Your Honor, to your question, under either standard, I think we would win, because if you look through the four requirements under Rule 6, the first one, again, being diligence, they were the opposite of diligent. It also involves good faith, and I think, it's hard to say there's an absence of good faith, but there were some representations made in the record and even in this briefing that just weren't, they don't show good faith. And there would be prejudice to us. Judge Rushing hit upon this. We'd filed our motion for summary judgment, expended money doing that. We didn't hire an expert because they didn't hire one. They missed the deadline. So all those elements we would meet, Your Honor, showing the prejudice. I think under Rule 6, if that's the test the court adopts. I know the Thompson versus DuPont case is cited. That was a case where a party missed the Rule 4 appeal deadline. And there was an analysis of if you had moved for an extension of the jurisdictional deadline before it expired, it was a good cause standard. If it was after, it was an excusable neglect standard. And I think that's probably one of the things that's got my brother at bar, that he talks about the expiration of the deadline and using Rule 6 then. I think that's inaccurate in light of Nurison and the other cases, Talley and Faulkner, Your Honor, Judge Rushing, those recent decisions on panels you were on. I think that's the applicable test. And I think, I don't think there was any abuse of discretion by the district court in finding a lack of diligence and finding they knew the product very early on. And I can cite to 4 or 5 instances where they knew that as we're lapping around the track. And Your Honor, I don't, I know there haven't been any questions about this, but I don't want to sit down without highlighting, the court granted a summary judgment, okay? The word summary judgment, I think, is in the other side's brief maybe once. They don't attack the independent findings of summary judgment.
Well, they seem to concede that if they don't have that evidence, that summary judgment would have been appropriate.
It seems that way to me, but they seem to concede, right? I haven't heard anybody concede that, but that may be the case, Your Honor. But I do think without an expert, they can't meet the standard, and we would prevail. But
And I know this is not litigated in this case. I will say one of my immediate questions is it immediately obvious that that even applies in federal court under Erie? But I think that's just totally unbriefed in this case.
it's unbriefed in this case, Your Honor.
Okay, but are you aware of this? The district court just seemed to treat that as if it obviously applies in federal court. Has this court ever held that this statute applies in federal court? I don't think so, but if we have, I'd like to know.
Not that I've found, Your Honor. I don't
But
think
like,
so.
is it within the knowledge of the average juror how a circular stapler works? And like whether this was designed appropriately?
It would
No,
not be,
right.
Your Honor.
You have to have an
It
expert,
couldn't.
whether a particular statute applies or not, right?
Right. And you know, Your Honor, that's right. You would need an expert to that point. And going to the stapler, Your Honor, one thing I forgot to mention, should there be any doubt, if you would have, at page 575, if you Googled the product number, a picture of what it looks like comes up. I mean, it looks kind of like the lighter you light fire with or candles that has the trigger on it for birthday cake or whatever. That's kind of what the device looks like. It has staplers in it and has to be able to, it's a laparoscopic procedure. It has to be inserted into the body. And there's a tactile feeling when you staple the two ends of the colon to the rectum.
So you haven't chosen to discuss it this morning, but you've raised it, and Steel Company. So you've argued we don't have appellate jurisdiction. Can you walk me through that? Because I don't think we can actually just not say anything about it. Whether we think that argument's right or wrong, we do have to say something about your argument that we don't have appellate jurisdiction.
Yeah, Judge Heitens, I think this ruling is clearly merged after the ruling of summary judgment. So
Great.
it's a final order. My probably inarticulate way of attacking this is that they don't brief. So I think I have to say the court has jurisdiction, right? But I think they have not fairly.
And the reason we do, just to be clear, is because this order that leads to the district court granting summary judgment in favor of your client, granting summary judgment in favor of your client is obviously a final decision
Yes,
under
sir.
28 U.S.C. 1291.
Yes, Your Honor.
Okay.
And my attack is more on the compliance with Rule 28, I guess A7 and 8 about the contentions. But to Judge
But that would
Rushing,
be forfeiture at best, or waiver, but that's not jurisdictional.
Your Honor, and I agree with you, and the court does have jurisdiction, so I will remove those remarks from my brief.
On the jurisdiction question, where are your clients incorporated and headquartered?
Your Honor, I think Ohio, I don't have that in front of me. It's clearly with our briefing. I'm embarrassed to say. I know the
I couldn't find it anywhere.
LLC. The LLC is the manufacturer of the product. The incorporated is the design and marketer of the product. And Your Honor, I know that the relevant folks were in Ohio, and I apologize, Your Honor, for not having that ready at my memory.
And it seems to be undisputed that the plaintiff is a citizen of South Carolina and South Carolina only.
That is my understanding, Your Honor. And that's all I had planned to present to this court. If there are other questions, I'd be happy to answer it. But from my perspective, I would ask this court to affirm, find no abuse of discretion, and apply Rule 16 the good cause standard, find the plaintiff didn't meet it, and affirm the summary judgment ruling in my client's favor. Thank you very much, Your Honors.
Thank you. We'll hear from Mr. Wyndham on rebuttal.
Just a few points on rebuttal. I think the jurisdiction argument has sort of been put to rest. I'm more than happy to get into our arguments on that, but my understanding is they've withdrawn that jurisdictional argument that this court, that we didn't appeal for the final judgment. I think ultimately, you're right, Judge Rushing, without that motion to extend the deadline, if that doesn't get granted, I think we're dead in the water. And I think we would concede that it is a complicated products case. Under South Carolina state law, you can bring a RESIPSA-like products case if you have the scalpel left in the stomach and, you know, how in the world did it get there? Under the facts, as I understand it in this case, Mr. Eichen has to have an expert, and if he doesn't, then he's just dead in the water. There's no way for him to prevail on his claims, specifically sort of the causation element of those product defects claims. I do want to talk about the email that my colleague brought up, because I do think, you know, one of those attachments to that email does identify the actual product number. But if you look at that email that begins at J, I think it's 326, you know, there are 5 different attachments that are a part of that email. And the original email is from Will Thomas, counsel at Grand Strand Regional Medical Center, and it's forwarded with very little information. It pretty much just says, you know, hey, we think you guys are the manufacturer, and then that's pretty much the same thing that's forwarded on to Mr. Eichen's counsel. I don't think at this point the fact that one of those 5 staplers was the stapler at issue just answered all of the questions. I do think there's maybe sort of, you know, another question that follows up. Well, you've got it narrowed down to 5, you know, why don't you do anything after that? And I think that the answer from trial counsel would be, you know, one, I think experts are extremely expensive, and the staplers themselves, if you look, I think it's the first attachment to that email. Some of those staplers cost up to $10,000. I think that, you know, the expert's going to need to get usually what they do is they will buy one of those staplers, and then they will perform various tests on it. And I think here you're looking at, okay, are we going to tell the expert witness, hey, here are 5 different staplers. We want you to go out, buy all 5, start preparing an expert report on all 5 of those. I think it would have just been prohibitively expensive. And I think at the time of getting this emails, Mr. Eichen's counsel really thought it was almost like an out-of-the-woods moment where, you know, hey, we've gotten some movement. We finally know that it's an Ethicon stapler. In early January, they dismissed the Covidian and Medtronic defendants. And so I think they were thinking that, hey, this thing's finally moving on. We're going to keep talking with
You keep saying finally moving on. I mean, these sounds like when you think that people are stonewalling you or not getting back to you, what you do is you file a motion to compel. You don't just blow deadlines.
I agree with you, Your Honor. I think maybe the thought process was that they didn't quite need one because it was sort of like they kept thinking they were getting closer and kept thinking they were getting closer, and so they didn't quite think. And I think part of it, too, was it was almost like I think especially with Grand Strand, more of an issue of, you know, it doesn't seem like they're withholding things from us. It just seems like they're having real difficulties finding who at Grand Strand Regional Medical Center would know this information and where are those files. And I think it is sort of kind of, I think, a little bit of a backlog from kind of, you know, the craziness of COVID within the hospitals. At least that's what I've been told is sort of why it kind of Grand Strand maybe didn't have everything that they needed to go with that. As far as sort of any discovery after the motion for summary judgment was filed, you know, I think in a perfect world, if I knew that it was going to take 6 months, you know, we would have, you know, of course, went and we would have kept going on discovery until the district court said, or they moved to say, hey, stop doing discovery on this, stop trying to find out. I think that the hope was the district court was going to rule on these motions pretty, you know, because it was ultimately hey, you either get more time and, you know, then you can go try to prove your claims, or you don't get more time, and then, you know, if we don't have an expert, then there's nothing to do. I do think if you look at the factors that the district court would have looked at, you know, I 100%, there's really no reason for going past that deadline. You know, it was deadline in the scheduling order that we did know about. But I do think if you look at, you know, there were things that were done both before that deadline and I think at the same time. And so I think for the district court to say, you know, that Mr. Eichen wasn't diligent, I think it's just a misunderstanding of the record. I also think when you look at sort of the other factors, I think they counsel in our favor, especially if you look at the prejudice to the other side. You know, I get it. They did file a motion for summary judgment, and that's certainly costs they've expended. But at the same time, you know, it's not like they can't go ahead and do discovery. They can still hire their own expert in the case. Where this case sort of stopped was really right in the middle of discovery, right when experts were about to start being disclosed, and then they would be deposed, and you'd be going back and forth on their expert reports. It's not a situation where you find in a lot of the cases where it's, 4 months, 5 months, 8 months past the deadline. Sometimes it's, a motion to amend a pleading to add a new party or a new claim in defense. I think the prejudice is much less than those other cases. And so for those reasons, we'd ask that you please reverse the district court's order granting summary judgment and deny Mr. Eichen his motion to extend that deadline. I'm going to remand with instructions to allow Mr. Eichen additional time to name an expert. Thank you.
We thank both of you for your arguments. We will come down and greet counsel after our deputy adjourns court.